So if he's
Mr. Michael Nowak on page 20.
Okay, and then we have the trial where the
Get your
jurors are
popcorn
outside,
ready.
I presume.
yeah,
Yes,
popcorn.
or well,
Here we go.
No, where are they? Okay, all right, as long as they're gathering up. All right, let's go to page 20. Michael Nowak. This is on for plea.
LV Medina Marcus on behalf of the state, and just for the
where
record,
the
Your Honor,
judge
there
at?
are
This is William
the victim's
Apfield.
family on the Zoom, if we can make sure
Okay.
that that's
Your Honor, Mr. Nowak is heading up the escalator now. There has been a very last minute change, material change to the plea offered by the state just this morning. So I am going to need time to relay this to him because it could be a deal breaker.
Okay, well, just to let you know, I'm supposed to be starting a jury trial in 5 minutes.
Judge, I know that we can come back tomorrow. The state has mentioned that the alleged victims are present.
yeah, the victims are present. They've taken off of work and off of school.
They're
and
present
are
on Zoom.
on the Zoom. They are with a lot of coordination to have this done today.
All right, is this your client here? No?
No, I believe he's an observer on this case who has presented threats to us in the past. So I would want to make the court aware of that. It was an issue the last time this gentleman recovered.
Okay.
You may want to inquire of him and why he's here.
Yes, sir. What is your name, sir? Yes. Okay, Mr. Jones, apparently counsel is saying that there have been threats made to him, and if there haven't, we're in a clean slate right now. But if I hear of anything from this moment on to anyone, you're going to have to answer to the court. Everybody is entitled to their opinion, but when we're in a court of law, when we're dealing with matters, there should be decorum and respect. So I just hope that everybody appreciates that. That's all I'm going to say. I'm not accusing you of anything, sir. All right? Okay. So you need to speak to him. You've got a new, is this going to be a written plea agreement?
There's a written plea agreement. There is one line that has changed. However, as defense mentioned, it does change the terms in terms of what was listed that they need to review and with the clients this morning.
All right.
It is one line.
All right, we'll pass it. Again, if it takes too much more time and I have my jury ready to go, I'm bringing them in. That's going to be my priority.
Understood.
You know. Okay, thank you. All right, and Stark.
Yeah.
Okay, no, all I can tell you is an allegation was made. Everybody's presumed innocent in this court, sir. All I wanted to do is let you be aware that they've made the allegation. It's a clean slate. Everything is good. Okay. Well, okay, we took care of the Nelson hearing. I will go off the record while we're waiting.
Be able to hear only that the victim and her mother are going to be able to hear this.
I do not know how to do that at this juncture. You had brought this to my attention.
It was brought to your judicial assistant attention
When?
in between the last hearing and this hearing.
Well, it is unfeasible right now.
I'd ask if the state assistant attorney can make an attempt to call them and have them here by phone. Because if Your Honor is going to be speaking and there's all of these individuals who are going to be here able to, they're not going to be able to talk, but they're able to live stream, and that's not what we're intending.
Folks, you're raising issues that the court was not aware of. I have a jury sitting outside waiting to come in. If you wish to reset this matter, this courtroom is always open. Zoom is a convenience. But as of right now, we do have those who are attending. I'm not going to just delete everybody from the proceedings. I honestly don't even know how to do it and just leave somebody able to hear everything.
It's being streamed right now live on YouTube.
Okay, well, if it's being streamed, it's being streamed. There's nothing I can do about that. But if the state and the defense wish to reset this for another date, this physical courtroom will be open to whomever wishes to attend.
Your Honor, I believe that it is an open courtroom, but the Zoom is not required.
I understand that, but I don't know how to go ahead and take out everybody except for one individual. They're already here. You're bringing this to my attention now. I'm given the opportunity. If you want to reset this for tomorrow, we can do that.
Your
I have
Honor,
a jury trial that is sitting outside the door.
the concession the state made regarding crossing out that last line, the last term, was with the understanding that this would happen today because of the victim being out of school, the people being out of work. If this gets reset, we're not willing to amend that term.
Can we have, Your Honor, the victim and her mother be put into a breakout room with the court so that only they are allowed to hear the proceedings?
Quite frankly, I can put someone in a breakout room, but then they're now prevented from hearing what goes on in this courtroom. We're not in a breakout room. You're putting me in a very difficult position.
Can the state attempt to call them?
We would ask that the proceeding proceed. We've confirmed that there will be no interruptions by muting everyone who is not needed to be heard during this procession. Courtrooms are open, and that's the nature of courtrooms.
Then we're going to go forward. That's all I can tell you. We're going to go forward. All right. So I have a 4-page plea agreement that was signed by the counsel and the defendant. It was signed on today's date. And on page 1, there is a line on paragraph 5. I cannot read what the handwriting says, so maybe somebody can assist.
Your Honor, the state has crossed out one line of paragraph 5 and has written on the side, this crossed out line does not apply, and then initialed and dated.
Line does not apply. Okay, and that's your initials there?
Correct, Judge.
Okay.
Your Honor, before you proceed with the plea, we do have an amended information that we're filing right now.
Okay.
The state, in case F21-14438, is filing an amended information for purposes of the plea and in contemplation of resolving the case of 2 counts of child abuse, aggravated, great bodily harm, or torture, felonies in the 1st degree, 1 count of contributing to delinquency of a dependent or dependency of a child, a misdemeanor in the 1st degree.
All right. So please arraign on the new information.
We enter a plea of guilty.
No, on the new, arraign on the new information. You're entering a not guilty plea at this point.
At this point.
Okay, and setting it for jury trial, all discovery to be provided. And are we ready to proceed?
Yes, Your Honor.
Okay, if I can have the defendant sworn.
Raise your right hand, the other hand. Do you swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Trial?
Okay, I'll need the old information. I want the defendant to be aware of what he was originally facing and what the new information. This is the new information.
I didn't give it to you? Oh,
I have
one second.
All right. Okay, can you tell me your full name and date of birth?
Michael Eugene Note Jr., August 10th, 1983.
All right, thank you. You were originally charged under case number F21-14438 with the following charges: lewd and lascivious molestation on a child, a 2nd-degree felony, punishable by up to 15 years state prison. Count 2 was lewd and lascivious molestation on a child, 12 to 16 years, a 2nd-degree felony, punishable by up to 15 years state prison. Lewd and lascivious conduct on a child under 16 by a defendant 18 or over, a 2nd-degree felony, punishable by up to 15 years state prison. Count 4, lewd and lascivious exhibition on a child under 16 years, defendant over 18, a 2nd-degree felony, punishable by up to 15 years state prison. And contributing to the dependency of a child, a 1st-degree misdemeanor, punishable by up to 1 year in jail. And then count 6 is interference with custody, a 3rd-degree felony, punishable by up to 5 years state prison. The state has now filed an amended information today, charging you with the following: aggravated child abuse, great bodily harm, a 1st-degree felony, punishable by up to 30 years state prison. Count 2 is aggravated child abuse, great bodily harm, a 1st-degree felony, punishable by up to 30 years state prison. And contributing to the delinquency, dependency of a child, a 1st-degree misdemeanor, punishable by up to 1 year in jail. It is my understanding that you wish to plead guilty to this new information. You would be adjudicated guilty, and your sentence has been memorialized in a 4-page plea agreement. Did you have the opportunity to go over this plea agreement with your lawyer?
Yes.
Okay. I do need the defendant to initial each page because there are not initials on these pages. All right. Let me know when it's done.
Approach.
Yes, sir. Now, it is my understanding, Mr. Nowak, that you have gone over this plea agreement with your lawyer, and I want to go over it with you, not each and every aspect of it, but the major components of the plea agreement. But what I am going to ask is for the state to tell me the general terms of the plea agreement, and then we will go into the details on the contract. Go ahead.
Your Honor, the plea agreement includes an adjudication, 7 years of state prison, followed by 10 years of reporting probation. As a condition of probation, the defendant
It's,
will.
what'd you say, 10 years
10
probation?
years reporting probation. The defendant will complete the MDSO program. The defendant will not be allowed to have unsupervised contact with children. The defendant will have specific terms regarding where he may work and the ability to wear a uniform. There are additional terms of restitution, of which $5,000 has been agreed to be paid upfront within 24 hours, mailed to the to the victim, and additional restitution to be paid out on a monthly basis once he is out of custody. And that monthly amount is highlighted in the written terms of the plea agreement. Additionally, there will be a stay away order from victim TS and her mother, which is also mentioned in the plea agreement.
What is the total amount of the restitution?
The total amount of restitution is $25,000.
Okay. All right.
Your Honor, is the defendant's counsel going to be providing probation with the proof of the $5,000 being paid?
Yes, Your Honor.
Okay. All right. Okay, so Mr. Nowak, the terms of the plea agreement are as what the prosecutor just stated, that you are going to be entering a plea of guilty to the 2 counts of aggravated child abuse and 1 count of contributing to the delinquency of a minor. You will be adjudicated guilty, which is a criminal conviction on your record. Do you also understand, sir, that by entering into this plea that it may subject you to involuntary civil commitment proceedings set forth in Florida statutes 394.910 through 394.931? Do you understand everything that I've said thus far?
Yeah.
Okay. Now, I want to also advise you, sir, that you are going to be sentenced to 7 years in state prison, to be followed by 10 years of reporting probation. In addition to any of these special conditions of probation, you will also participate in and successfully complete a mentally disordered sex offender treatment program, that you are also not eligible. Okay, you may, according to the state, you may be eligible for early termination if all of the conditions of your probation have been completed, that you have had no violations of your probation, and that you have not been arrested for any other criminal offense. Is that correct, State?
And to clarify, the terms stated in 5 is there is no prohibition on early termination. However, there is a requirement that any modification to this agreement be agreed by the state and the court.
Okay. All right, sir. Now, with respect to this plea agreement, I have on each page next to defendant's initials MN. Did you in fact affix those initials to each page?
I did.
And have you reviewed each and every component of this plea agreement going through page 1 and through page 4?
I have.
Now it says on page 4, having read the above mentioned terms of this plea agreement and having been advised by my counsel, David Terrace, I, Michael Noak, freely and voluntarily enter into this plea agreement and agree to abide by all terms and conditions of this plea agreement, and agree that failure to comply with any terms or conditions within this agreement constitutes a violation of probation and subjects me to be sentenced to the statutory maximum penalties provided by law for the crimes for which I am now pleading guilty. And then it has a signature over the name Michael Noak. Is that in fact your signature, sir?
Yes, sir.
All right. And I am now going to place my signature on this plea agreement, in that I am now going to be ratifying this plea agreement as negotiated between the state of Florida and your attorney. Has anybody, including your lawyer, told you anything differently than what I've just told you?
No.
Are you under the influence of any alcohol, drugs, or medication affecting your ability to understand me?
No.
Is anybody forcing, threatening, or coercing you to enter into this plea?
No.
Do you understand that if you're not a United States citizen, the entry of this plea will have negative immigration consequences, including deportation and removal?
Understand.
You had the right, sir, to have gone to a jury trial where your lawyer had the ability to compel the attendance of witnesses on your behalf, the ability to confront and cross-examine the witnesses and evidence against you. You had the right to testify just like any other witness or remain silent, and your silence could not have been used against you if you went to a jury trial. You also had the right to appeal any mistakes that I would have made during the course of the trial, and the right to hold the state of Florida to the burden of proving these charges beyond a reasonable doubt. Do you understand, sir, that by entering into this plea, that you are giving up all of these rights and we will not have a jury trial?
I do.
Have you discussed this plea with your lawyer?
Yes,
Has he answered all of your questions?
absolutely.
Are you satisfied with your lawyer's services and advice?
Definitely.
Did the state provide all the discovery in your possession to the defense?
Yes,
Did the defense review all of the discovery in your possession with your client?
Yes, Your Honor.
And do both sides know of any physical evidence containing DNA that would exonerate the defendant?
no,
No, Your Honor.
And do both sides stipulate to a factual basis for this plea?
yes,
Defense stipulated.
And the court has reviewed the arrest affidavit, makes a finding that there is a factual basis for the plea. Mr. Noack, are there any witnesses or is there any evidence that you wanted your lawyer to investigate or me to receive before entering into this plea?
No.
All right. The court finds that the defendant understands the nature of the charges against him and the consequences of this plea, that he has been represented by competent and effective assistance of counsel with whom he says he is satisfied. I find the defendant has knowingly, voluntarily, and intelligently waived his rights. All statutory fines, court costs, and surcharges will be assessed. Counsel, do you waive PSI?
Yes, Your Honor. Yes,
All right. Now, Mr. Noack, you do understand, as I mentioned to you before, that the state, as they had articulated earlier, you may be eligible for early termination as long as certain conditions are met. That means no violations. You've done everything that you were supposed to do. You've not been arrested for any criminal offense, and the state is in agreement with it as well as the court's ratification. On the other hand, sir, if you violate any terms and conditions of this probation, and that includes getting arrested for any other criminal offense, that you could be subject to the maximum period of time in prison, which by my calculations is 61 years state prison. You do understand that?
Yeah.
And knowing all of this, do you still wish to enter into this plea?
Yes.
All right. The court finds the defendant, as I mentioned before, understands the nature of the charges against him and the consequences of this plea, that he has been represented by competent and effective assistance of counsel with whom he says he is satisfied. I find the defendant has knowingly, voluntarily, and intelligently waived his rights. All statutory fines, court costs, and surcharges will be assessed. Is there anything further as it relates to Mr. Noack? I do have on the Zoom that the victim's mother wanted to address the court as part of the
correct.
victim
Your Honor,